Welcome to the third panel of this conference, entitled Crimes Within the Tokyo Charter, Crimes Against Peace, War Crimes, and Crimes Against Humanity. Now, with this theme, you can see that we are delving into an area that is perhaps somewhat more technical than the broad historical political significance of the IMTFE. Nevertheless, we would endeavor to discuss the substantive content within the subject matter jurisdiction of the tribunal, as well as how the provisions came to be included and what impact, if any, some of those provisions, especially the deviations and the different formulations of some of the crimes, may have had in the subsequent development of international criminal law. Now, with us today are three eminent speakers. We would start with Professor Philip Austin, who is Professor of Criminal Law and International Criminal Law at Keio University. And he will be talking about the definition and scope of the crimes within the Tokyo Charter, encompassing all three crime categories. Professor Austin will be followed by Dr. Wolfgang Form, who is a lecturer in political science, criminology, and peace and conflict studies at the universities of Marburg, Kiel, and Wolfenbüttel, who will enlighten us on the two specific crime categories, namely war crimes and crimes against humanity at the IMTFE. And then we would have Professor Donald Ferencz, also known as the Michael Douglas of International Criminal Justice, who will enlighten us on not only in his appearance, but also, of course, the pedigree and the prominence that the father and son both enjoy, who will tell us about the criminalizing aggression from Nuremberg to Tokyo to The Hague. With that, I would give the floor to Professor Austin.
Thank you, Dr. Hayashi, for your kind words of introduction. Ladies and gentlemen, I would also like to thank, of course, the organizers of this conference for inviting me and giving me the opportunity to share some thoughts with you today. Even though after this lunch break with lots of Nuremberg Würstel, I think I will have to try to not bore you too much with a few technical legal problems. My presentation will try to provide a general introduction to the crimes falling under the scope of the jurisdiction of the Tokyo Tribunal as they were defined in Article 5 of the Charter. I will try to shed light on some of the most significant modifications in the definitions of the three crimes as compared to the Charter of the Nuremberg Tribunal. I would also like to outline legal consequences of such particularities with regards to the applicability and interpretation of crimes and the possible relevance of these matters for the further development of international criminal law will also be briefly touched upon, as well as, time permitting, the Japanese scholarly debate in this regard. The Tokyo Charter was, as has been pointed out already, modeled on the Nuremberg Charter and stipulated three categories of crimes. However, the definitions of the crimes differed from those in Nuremberg in several respects. These alterations, as we shall see, have consequently deeply influenced the way how these crimes were applied in Tokyo. Crimes against peace were the central charge of the Tokyo trial and constituted the heartbeat of the court proceedings. As Diane Orentlicher and others pointed out, unlike the Nuremberg Charter, Article 5 of the Tokyo Charter explicitly limited the scope of persons to be tried at Tokyo to those who are charged with offenses that include crimes against peace. In line with the overall prosecutorial strategy, the Charter, and thus the tribunal as such, was construed to try the Japanese leadership primarily for crimes against peace. The ultimate goal of the trial was to punish Japanese aggression. As a result, nearly all defendants were found guilty of charges pertaining to this group of crimes. The focus on crimes against peace was even higher, maybe even far higher, in the Tokyo trial than at Nuremberg. The court, in its majority judgment, while holding aggression criminal, refrained from providing an express definition of aggression. To this end, the court adhered entirely to the Nuremberg judgment and presented no legal reasoning of its own. This was also, of course, conceived by critics of the trial as a decisive legal weakness. The central role of crimes against peace, in the eyes of many, not only Japanese scholars, is, of course, combined with criticism related to conspiracy, to retroactivity and selectivity, the main reason why the Tokyo trial was and is more controversial than its Nuremberg precedent. The definition of crimes against peace in the Tokyo Charter had been constructed on the Nuremberg model with one, actually there were two, but I will only point out one significant modification. The words declared or undeclared were added to the term war of aggression in order to underline the understanding that the formal manner in which a war was commenced or qualified by one of the belligerent parties was immaterial to determining its legal character. This alteration clarified that this crime could also be applied to the undeclared wars which Japan had conducted over many years, in particular in China. It is interesting to note that a strikingly similar wording has also been adopted at the Kampala definition of the crime of aggression, which is now incorporated in the Rome Statute of the ICC, the term regardless of a declaration of war. Arguably, this could be regarded as an indication for a unique impact of the Tokyo Charter on the present-day development of this legal concept. In this respect, the Charter and the related jurisprudence, to some degree, perhaps might receive more attention in future, considering the activation of ICC jurisdiction on the crime of aggression from this summer on. In contrast, the novel concept of crimes against humanity played a minor role in Tokyo. It was practically not conceived as an independent category of crimes. While the Nuremberg Tribunal had only 4 counts for indictment, there were 55 counts in Tokyo, which were separated into 3 groups. 2/3 of all counts pertained to crimes against peace, the first group. The remainder of counts was indicted as murder, Group 2, which was actually not provided for in the statute and eventually was dismissed by the court, and as conventional war crimes and crimes against humanity, the third group, with only 3 counts. Thus, crimes against humanity were not dealt with separately, but combined with conventional war crimes. The judgment limited its findings on this last group to only 2 counts. The prosecution did not submit evidence to establish specific crimes against humanity, even though it was initially planned, to the effect that no defendant was convicted of singular crimes against humanity in Tokyo. Compared to Nuremberg, the most significant modification in the definition was the deletion of the wording acts committed against any civilian population. Thus, the object, the target of crimes against humanity under the Tokyo Charter was not limited to civilians, with the effect that this provision could also be applicable to inhumane conduct against combatants. The decisive difference in the concept of crimes against humanity lies, therefore, in the non-limitation of the scope of persons to be protected by this notion. As has been frequently pointed out, the concept of crimes against humanity at Nuremberg was originally drafted with a view to the prosecution of crimes against humanity of ideologically motivated Nazi crimes, namely crimes against persons who did not fall in the scope of conventional war crimes, in particular own citizens of the offending state or nationals of third states. However, by extending the scope of crimes against humanity to enemy combatants, it became difficult to distinguish crimes against humanity from conventional war crimes. Considering these alterations, it is not altogether surprising to see that the indictment at Tokyo did not charge crimes against humanity committed against Japanese subjects on Japanese territory, which would at least theoretically have been conceivable, at least in view of the colonies annexed by Japan, such as the Korean Peninsula and its, at that time, Japanese citizens. Furthermore, the court in Tokyo adhered to the restrictive jurisprudence of the Nuremberg trial on the connection of this crime with the other 2 crimes falling under its jurisdiction. The IMT presupposed a nexus between crimes against humanity on the one hand and war crimes or crimes against peace on the other hand, meaning basically a linkage, a link to an international armed conflict, which further narrowed down the scope of applicability of crimes against humanity. By restricting crimes against humanity to those closely connected with the war, contrary actually to the wording before or during the war, which was also in the Charter, practically no pre-war crimes against humanity, meaning acts committed in peacetime, could be tried in Tokyo. Today, an attack against any civilian population is regarded as the most significant characteristic, as a crucial foundational element of crimes against humanity. Thus, the omission of this element at Tokyo turned out to be a historical flash in the pan. As no substantial discussion of the concept of crimes against humanity occurred in Tokyo, this trial certainly had no precedential effect on the further development of this notion. The notion of conventional war crimes and its criminality as such did not give rise to much legal controversy at the Tokyo trial, since it could be based basically on customary international law. Some of the most infamous atrocities, wartime atrocities committed by the Japanese armed forces were adjudicated under this category of crime. In this regard, the most significant legal aspect was, however, the mode of individual criminal responsibility, or the mode of imputation, which was adopted at Tokyo for war crimes. The doctrine of command, or as it is now called, superior responsibility, was, as has been pointed out by many researchers attending this conference, applied and also further developed at the IMTFE with a view, in particular, also to the responsibility of civilian superiors. It is here that the court was perhaps most creative and influential in terms of presenting substantial legal discourses and perspectives. These cases were repeatedly referred to as precedents and were extensively discussed in the jurisprudence of the ICTI and the ICTR from the beginning on. Finally, it should also be mentioned that the tribunal imposed the most severe punishment, the death penalty, on those accused who were convicted of war crimes, and not on those who were found guilty on charges solely pertaining to crimes against peace. This sentencing practice is even more noteworthy considering the heavy focus which was put on crimes against peace throughout the court proceedings. Arguably, this could be indicative of some rudimental reasoning regarding the gravity of the different crime categories, which was already apparent in the Nuremberg judgment, and which also was expressed in the separate opinions of some of the judges at Tokyo. The question of a possible hierarchy of international crimes and corresponding sentencing principles is, however, highly disputed even today. In any case, it remains rather questionable whether the Tokyo trial can provide any precedential guidance in this regard. In lieu of a conclusion, let me briefly sum up my findings with a view to the initial question whether the three crimes as they were applied and interpreted in Tokyo served as precedents. In the order I presented the crimes, a very simplified answer would be 1, perhaps a little bit, 2, definitely not, 3, yes. I think consensus predominates this conference that the Tokyo tribunal can no longer be just regarded as a mere footnote or an add-on to the Nuremberg trial. I agree entirely with this overall assessment. It is regrettable that the Tokyo trial was, until the past 2 decades, often overlooked or marginalized in the international debate. Recently, however, at least with regards to some substantive law issues related to the three crimes at Tokyo, a tendency to the opposite extreme can sometimes be encountered. To this end, one should be perhaps careful to not overestimate the precedential impact or value of all aspects of the Tokyo Charter or its judgment. As to the impact of the trial, just one final word on the Japanese debate. Some legal concepts which are now generally recognized in international criminal law were, as we heard from Yuma Totani, already anticipated by outstanding Japanese legal scholars in publications on the Tokyo trial more than 70 years ago, but are more or less forgotten today. Today, it is interesting to note that while outside of Japan, the legal contribution of the Tokyo trial is increasingly receiving reappraisal, within Japan, only a very reluctant legal reassessment of the trial, if any, can be seen. Unlike historians, Japan's present-day legal academics display a certain reluctance to conduct research on the Tokyo trial. Today's legal scholars mainly prefer to stick to the current flow of international criminal law. In sum, the Tokyo trial did not give rise to the emergence of an elaborate international criminal law scholarship in Japan. Thank you very much for your attention.
Thank you, Philip. Now I give the floor to Wolfgang.
Thank you so much, Nobuo, for the introduction. I will give some more information about these two crimes against humanity and war crimes. But I start with what was happened before. The Moscow Conference, it was agreed that between the UK, the US, and the Soviet Union, that the Supreme Commander shall issue all orders for the implementation of the terms of surrender and so forth. And who did that? MacArthur. He was acting as a Supreme Commander for the light powers, established the tribunal for the trial of those persons charged individually or as a member of organization or both capacities with offenses which include crimes against peace, war crimes, and crimes against humanity. I come to the jurisdiction of the tribunal, and I do it really briefly. I begin with crimes against peace, as we heard before from Philip, that the big difference between the EMT and the Tokyo Tribunal was because of the it was declared for an undeclared war of aggression. That would be very important for the story after that. Conventional war crimes, of course, different to the IMT was that the conventional, what is a conventional, but at the end of the day, it was not so much different. Like Philip explained, it was pretty clear what war crimes could be in the first hand, like that was a description in the Hague Convention and the Geneva Convention. The contrast to the IMT Charter was that don't find any specification of war crimes in the Tokyo Charter. About the IMT, you are reading murder, ill treatment, or deportation to slave labor, or for any other purpose of civilian population, or in occupied territory, murder or ill treatment of prisoners of war or persons at the sea, and a lot of more. In this prospect, the judges told that it was not necessary to do that. It was okay. They don't need that. Depends on that, what Philip told before. It was pretty clear what they were deal with. War crimes, according to Oppenheim, and that was one of the famous British commentator, are such acts of soldiers or other individuals as may be punishable by the enemy on capture of the offenders. So, in this perspective, they had the idea that there must also be a lot of people that were responsible, especially in the high category of the Japanese government, military, and also in civil organization. Responsible for to care of prisoners of war and civil internees, this was another thing, therefore was, of course, the government. They having this position to do that. That means notably acts of inhumanity to all kind of prisoners and forbidden by the customary law of nations as well as by conventionaries are to be prevented by the government. That was what they should do, having responsibility for them and, in the first case, by those a person who constitute the government. And of course, if they are a person they don't do that, they are responsible for that, what they not did. In the Tokyo Tribunal indicated such person, of course. In Tokyo, you have so-called A cases. We also know B and C cases. We cannot go deeper in this problematic, but it's very important that what is the difference between a B and C and a war criminal? That is and was not really clear until the end of the composing of the indictment. The court explained very clearly who was guilty for such war crimes. Quote, a person is not excused for inaction of his office required or permitted him to take any action to prevent such crimes. On the other hand, it is not enough for the exculpation of a person otherwise responsible for him to show that he accepted insurances from other more directly associated with the control of the prisoners, if having regard to the position of those others, to the frequency of reports and such crimes, or to any other circumstances. I think that's very important that they pronounced that very on the beginning of the judgment, that it was quite clear who is in the focus of a war criminal. Cabinet members who were responsible, and I think that's very important, on the view of the judges for the care of prisoners, so the tribunal, and not resigned immediately after getting knowledge about war crimes, they are guilty. So that was the switch. If they resigned, then they were out of the focus. If they didn't, they were in. The crimes against humanity, a total other question. Over 90% of the IMT and IMTFE are very similar, except two things. As we heard before, against any civilian population, it was cut out, and they cut out religion backgrounds. In the IMT in Nuremberg, here in this room, they brought in, of course, of the European, of the German historical background, religion ground of prosecution. The most significant difference to the IMT Charter was that this putting out against any civil population by unarmed, by an amendment, it was in April 1946. Interesting is that in the literature you often find the version from January 1946, and not this one from April. In the end of the day, that shows us a more general focus on the crimes against humanity, civil and non-civil population. The US Chief Prosecutor Keenan, he was the so-called mastermind behind that modification, so you can read in this wonderful book from Philip from 2002. He tried to implement the crime murder for killing allied prisoners of war in the indictment. As we will see a little bit later, it doesn't work. In addition to this, include combatants into crimes against humanity brought a massive delimitation problem to war crimes. It was unclear who crimes against humanity ends and war crimes begins, or on the other hand, it was difficult to decide which acts in wartime against civilian population are crimes against humanity and which war crimes. That was quite clearer in the IMT. For me, it was interesting to read that ruling. We heard about him yesterday and Always a Day, appreciated that crimes against humanity in the IMTFE version is, so he called, a badly drafted article because of the ambitious interpretations. In the Tokyo Charter was under crimes against humanity, I told you before, religion not included. It looks like that there was no reason for such definition in crimes against humanity. Different to the European theater of war, prosecution of religion backgrounds were a relevant Nazi politic before and during the war. In the Charter of Nuremberg and Tokyo, connecting crimes against humanity with other crimes within the jurisdiction of the tribunal. That was similar in both charters. The connection in both charters was desired because some political and military personnel were afraid that without this element, crime would be applicable to a mistreatment in their own past. For example, the Afro-Americans in the US, and we have a lot of other examples. With other words, dealing with internal politics. However, in the case of Japan, in contrast to Nazi Germany, it did not make such sense. The jurisdiction of the IMTFE goes back to the end of the 1920s, and there were no Japanese atrocities against their own population in armed conflicts. Another difference to the IMT Charter is that subparagraph 5, in Article 5, they called leaders, organizers, and others in the formulation of execution of a common plan and conspiracy to commit any foregoing crimes, etc., is not in independent paragraph. It's incorporated in the subparagraph C. It stands for crimes against humanity. Does that mean that conspiracy or common plan also valid for crimes against humanity? The court says no, it's only related to crimes against peace. That was, for example, a very important part of that count 37 to count 52 were put out of the indictment before court. They said that murder is not, and murder was only labeled by crimes against humanity, was not a part of the crimes against peace. And in this regard, they put that out. So that means that in the end of the day, only crimes against peace and, in some circumstances, war crimes were charged before the court. Many counts focus on the time non-declared war from 1928 or 31 to the end of 1941. This is an evident difference on the IMT. Nanjing and other massacres in China took place in the 1930s. In this regard, the Tokyo Tribunal was very clear. A war of aggression started at least at September 1931. The judges declared, I quote, "We have found that the war in China was, from 1931 onwards, a war of aggression." That was, in this regard very important. Then, without war, and the war it fall under the Charter, there was no war crime. That means, without this definition that there is a war crime, could begin in 1931. In this perspective, all acts they can show as a war crime in this non-declared wartime is a war crime. And for me, that is a very modern view of this circumstance. For charging crimes, I'm coming now very briefly to crimes against humanity back. All in all, this crime plays, we heard about a very small, minor role in the judgment. We see that already in the indictment itself. Different to the IMT indictment, crimes against humanity was not a distinct charge group. We find crimes against humanity more or less as an appendix in the count 53 to 55. Responsible for this fact were differences to the Nazi politics on prosecution of their own population. On no place at the judgment we find the term crimes against humanity discussed. We find the term humanity 13 times written in over 1,400 pages. Some indications regarding to human acts, unhuman Japanese military operation, and others are be found. Only in the verdict against Shigemitsu, I hope I pronounced that correctly, ordered, we find crimes against humanity. I quote, "There is no evidence that he ordered, authorized, or permitted the commission of war crimes or crimes against humanity. The tribunal finds him not guilty for count 54. As we see, he was not charged for crimes against humanity, and it looks like that the judges use the phrase crimes against humanity more or less like we know that today as copy and paste, as the textbook block from the indictment. In the Tokyo judgment is nothing compatible to the many pages of the Nuremberg judgment focused on crimes against humanity. The defendants were exclusively convicted by conspiracy and or wedging a crime of aggression and or war crimes. I have some remarks and questions to the panel here and also for the audience. Most of the courts are most of the counts were not accepted by the court. Was that a fundamental prosecution failure? If the court did accept these counts, and in particular crimes against humanity, did the sentence were different? For at least 7 accused, definitely not. Depends on they were sentenced to death. But if the prosecution did their job better, we could have today a broader jurisdiction on crimes against humanity, especially about the time on undeclared war. And last but not least, was it wise including crimes against humanity in the Tokyo Charter? We must have in mind that crimes against humanity was created in World War II in Europe for punishing atrocities from Germany against Germans. Do we find similar situation in Japan? I think, of course, yes. Comfort women in Korea. And at least, 2 seconds, United Nations War Crimes Commission. Nuremberg, we find on several places, on several memos, we find papers. In Tokyo, only 3 hits. Thank you so much.
Thank you very much, Wolfgang. Now the floor goes to Don.
Thank you. So what are we doing here, us in this room? I look around, and I think I can't help but be reminded of what happened in this room, where Robert Jackson started off with the flowery language. You've all heard it before, and you'll hear it now, that 4 great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law, is one of the most significant tributes that power had ever paid to reason. Beautiful language, but it's not what he came here for. That's not the speech he came here to give. The speech that he came here to give was at the end of his opening statement, and I want to share it with you. He said, "Wars are started only on the theory and in the confidence that they can be won. Personal punishment to be suffered only in the event the war is lost will probably not be a sufficient deterrent to prevent a war where the war makers feel the chances of defeat to be negligible." He's talking about the notion of holding the victors to justice. For him, that's what Nuremberg was about, not punishing the defeated, but saying to the victors in this war that the victors in the next war, if they commit aggression, will be held to account. He goes on in the final paragraphs to say, "But the ultimate step in avoiding periodic wars, which are inevitable in a system of international lawlessness, is to make statesmen responsible to law. And let me make clear that while this law is first applied against German aggressors, the law includes, and if it is to serve a useful purpose, it must condemn aggression by any other nations, including those which sit here now in judgment." That's what Nuremberg was about for Robert Jackson. It was about setting a precedent for the future to say to powerful countries, you can't rely on force, you must follow the rule of law. Protecting not simply the powerless from the powerful, but protecting the powerful from themselves. And I really wanted to emphasize that because when we spoke this morning and we talked about victor's justice, this is not what Nuremberg was about for Robert Jackson, certainly not for Robert Jackson. Now, we talked about some other things this morning. I'd like to just throw a few little comments out to you before I get into talking a little bit more about aggression, which was the centerpiece, by the way, crimes against peace. For the Americans, there was a comment earlier today that there was a, quote, smooth consensus in Nuremberg. Well, I beg to differ with that, at least as to the crime of aggression. In the London conference, it was very obvious that neither the British nor the French were interested in pursuing charges for crimes against peace. And that situation hasn't changed very much today, and I'll say a little bit more about that. But I want to touch on something else, too. The ex post facto question. It's mingled in with the whole victor's justice issue. Was Nuremberg, was Tokyo ex post facto? Well, there's a quote that Ambassador Rapp knows very well, and I know very well, which I have recited many times without ever really thinking about why Justice Jackson, right after his four great powers paragraph, in his very next paragraph, he says something. And I've recited it many times because it's compelling. And I want to recite it to you, and then I want to think about it with you. He says, the common sense of mankind demands that law shall not stop with the punishment of petty crimes by little people. It must also reach men who possess themselves of great power and make deliberate and concerted use of it to set in motion evils which leave no home in the world untouched. Why did he say that? It's an apology. They were making up the law as they went along. He's saying, he didn't say, these guys have broken this law, this law, this law. He starts off by saying the common sense of mankind demands this. So he's talking about a natural law. He was apologizing, I think, for his own awareness that the argument that there was not a pre-existing prohibition in international criminal law, certainly, for taking your nation into even an illegal war, as we heard discussed this morning. After World War I, that was the finding of the Commission. Now, Kellogg-Briand, very interesting. I want to tell you one quick story. Raise your hand if you have heard of the Kellogg-Briand Pact. Okay, not everybody in this room has, so let me just take a minute to quickly say, Kellogg-Briand Pact was a pact between the United States and Paris. It was It was proposed by the Aristide Briand, French minister, to the Americans. He did something that really got the Americans very annoyed. Frank Kellogg was the American Secretary of State. One day he opens the newspaper, and there's a letter from Aristide Briand to the American people saying, we want you to join us in a perpetual friendship agreement. They were very angry in the State Department. They waited several months. They finally got back. They said, let's open up this declaration of perpetual friendship to the whole world. We'll have a treaty for the renunciation of war as an instrument of national policy, and everybody can sign it. Why did they do that? They didn't want to be in a bilateral agreement with France that could suck the U.S. into the next French war. Well, that treaty, when it came up for a vote in the U.S. Senate, was overwhelmingly approved. And some of you have probably heard me tell the story. Only one person voted against it. And I thought, what crazy madman would vote against the treaty for the renunciation of war on which the Nuremberg judgment is based, saying the Germans violated the Kellogg-Briand Pact? It was John James Blaine, Republican senator from Wisconsin, who stood up on the floor of the U.S. Senate on January 9th, 1929, and it's in the congressional record, that's how I know this. And he said, knowing that the treaty had no sanctions, no provisions for its breach, no criminal enforcement, and he knew something else, which I'll come to in a moment. He knew that the British and the French and the Americans had filed declarations, which we would call reservations today, to the treaty, saying the following, saying, we're going to sign this treaty, but we reserve for ourselves the right to use force anywhere in the world that we feel our interests need defending in our sole discretion. And here's what he said. He said, if this treaty did what it said it would do, I would vote for it. He said it is a, quote, sham. And he said, weighted down by the reservations, the treaty contains the fertile soil for all the wars of the future. In fact, he even went on. He said, this treaty isn't even a truce. It portends an early conflict that is imaginable only in the mind of the infinite. He was talking about something that he was predicting in 1929 as the obvious outgrowth of a treaty which had no enforcement mechanism. Okay. And I'd like to emphasize it because it's a precursor of some of the discussion we're going to have about where we are today. So let's fast forward a little bit. Let's ask, where are we now? What's the real legacy of Nuremberg and the real legacy of Tokyo? Well, there was an article in the New York Times last March 2017, and there was a quote from the current United States Secretary of Defense, James Mattis, used to be a Marine general. He gave advice to his men upon the invasion of Iraq. Some of you may remember in 2003, without a UN resolution, the United States, Britain, and others decided to have a regime change. And here's what he said to his troops. He said, be polite Be professional, but have a plan to kill everybody you meet. A little bit different from the flowery language of Robert Jackson. Now, when the trial was over, Robert Jackson wrote a letter to the President of the United States. He wrote to Harry Truman on October 7th, 1 week after the judgment, explaining to the President what had happened in this room. And he said, no one, now I think what he was thinking about was the whole ex post facto argument. Before Nuremberg, there was uncertainty. And he says, now, says to the President, no one can hereafter deny or fail to know that the principles on which the Nazi leaders are adjudged to forfeit their lives constitute law and law with a sanction. So he's saying, if it was ex post facto coming into Nuremberg, it's not ex post facto coming out. In fact, I disagree with his statement. Nuremberg was a limited court, limited jurisdiction, limited composition. So what did the United States do? Harry Truman, on the advice of Biddle, who had been one of the judges here, pushed forward a resolution before the General Assembly. It was referred to this morning, I think, briefly, in December of 1946. By unanimous approval of the General Assembly, a resolution affirming the Nuremberg principles was adopted. So we may say that in international law, that moment made the crime of aggression, still called crimes against peace, it was wars of aggression then, a crime in true customary international law. And of course, that was before the the Tokyo judgment was rendered. So, okay, so that's a little bit of the background. Harry Truman, by the way, stood before the General Assembly in October of 1946, and he said, I remind you, the 23 members of this body, that is the people who are already affiliated with Nuremberg, have already taken themselves under the yoke of the law as to these crimes that say that waging a war of aggression is an international crime for which leaders will be brought before the bar of international justice. So the Americans at that time were really pushing for this. Then we had the Cold War, and then we had efforts to criminalize aggression, defining the crime of aggression at the level of the United Nations. There was some progress in the 1970s, a definition was put out there. And then we had the establishment of the International Criminal Court in 1998. We had an effort to define the crime of aggression for purposes of activating its jurisdiction within the Rome Statute. I was told by a State Department attorney during the Bush administration, and I quote, we don't have to kill it, speaking of the crime of aggression. The Brits and the French will kill it for us. It's a quote. The British and the French have not ratified the amendments on the crime of aggression, although half of the NATO members have. We can say more about it if people have particular questions on it. I want to wrap up, sort of truncate this, with another quote from Nuremberg, and some of you have heard me quote it before, from one of the defendants, Hermann Goering. And the last time I was in this room, I quoted this. It's the reason why people like Jackson felt we need to hold leaders accountable to law. Goering said in an interview in his jail cell in April of 1946, he was being interviewed by an American army psychologist, Gustav Gilbert. Goering said, naturally, the common people don't want war, neither in Russia, nor in England, nor in America, nor for that matter in Germany. That is understood. But after all, it is the leaders who make policy. And it is always a simple matter to drag the people along, whether it is a parliament or a communist dictatorship, voice or no voice. The people can always be brought to the bidding of the leaders. That is easy. All you have to do is tell them they're being attacked and denounce the pacifists for lack of patriotism and exposing the country to danger. And then he added, it works the same way in any country. That's why we're here.
Thank you very much, Don. Now that we have approximately 15 minutes to ourselves before opening up the floor to general discussion with the audience, I was wondering if any one of you would have any questions or comments vis-a-vis each other.
I have a question. It's a question for anybody in the room. I'm not I don't hold myself out as a Tokyo scholar, and I'm not. I read a few things to try to prepare for this, but I do know something about the current efforts on crime of aggression. Unlike Nuremberg, at Tokyo, in order to be found guilty of the other crimes, you were also being charged with the crime of aggression. And I don't know, but I'm guessing there's somebody in this room who knows how that came to be. Anybody know?
So this is speculation on my part. I think it may be a hangover from the initial plan that Macarthur had, that the trial was to be the trial of Pearl Harbor. And therefore, crimes against peace were to be the only charge. It was only when the other allies came on board and said, no, we're not having that, that the Charter had crimes against humanity and war crimes added. And I think it was probably a failure to redraft the whole thing properly.
Oh, and Macarthur also tied to that the charge of murder. He was the one that wanted murder for the death of American servicemen and civilians at Pearl Harbor. So he linked the two together, crimes of aggression and murder, and that's the reason he had so many murder charges in the indictment.
My understanding is that at the planning stage of a Tokyo war crimes trial, at the intergovernmental among the Allied governments, there was a general agreement that there should be another Nuremberg-style international tribunal at Tokyo, which by that it was from the diplomatic correspondence, as I understand it, there was an understanding that crimes against peace would be the core crime to be prosecuted at the Tokyo trial. So when the American attorneys came to Tokyo in December 1945 to assist General Macarthur with the preparation of the Tokyo trial, and when they were tasked with the drafting of the charter of the Tokyo Tribunal, they included in the Article 5 or Article 6, in which the types of offense, charge of offense are listed. There's a phrasing to the effect that prospective individuals who will be prosecuted will be charged for various international offenses, including crimes against peace. And Keenan, when he was appointed as chief prosecutor, probably interpreted that as meaning to require the charge of crimes against peace to whoever individuals to be selected for the trial at Tokyo. So that's my understanding.
Thank you very much for these contributions from the floor. Do you have any questions for each other's presentations?
Maybe another comment to yours, Dan. I think we should not forget that there is another crime. It's let me see, on the left or the right side of crimes against peace. That's conspiracy. And in my perspective, it's also very important that the United States, for example, they have had the idea that this crime is, let me see, the starting point for all the others. If they haven't had, let me see, in the causality, no conspiracy, then it's not so easy to declare that's a war of aggression. So that's, I think that's clues together, but they are two different things. So your question must maybe focus on both, not only on crime of aggression.
Philip, you had comments or questions?
I agree with what Wolfgang just stated, and the conspiracy element was combined with the notion of crimes against peace, and was one of the most important factors. But if you have a look at the counts which were actually charged, I think there were only 5 or 6 conspiracy counts related to crimes against peace. The rest, the major part of the charges, were substantive crimes, especially related to waging the war. And it is true that in the court proceedings, and especially if you look at at the arguments of the Japanese defense attorneys, that the concept of conspiracy was unknown in Japan and was contested, of course, at the court. But if you look at the charges, it didn't play such a huge role. But on the other hand, of course, it is correct to say that of these charges related to crimes against peace, the first conspiracy charge was the most important one, which tried to present a narrative that there was a conspiracy from, when was it, 1928 to 1945, starting from the Tanaka Memorandum to conquer the world. This was, of course, the backbone of the whole indictment in Tokyo. Yes.
Thank you. Now, I have a couple of questions for all of our panelists. In fact, depending on how you counts, maybe 2 or 3 questions. And this has been kind of lurking behind the back of our heads, I suppose, since yesterday. The whole question of retroactivity, one of the elephants in the room, I suppose. But in connection with that, I noticed that in the context of the Tokyo Tribunal, there is already this sort of practice of judicial engineering, where you modify, not only at the stage of rendering judgments, we know that the judges make interstitial law, but already at the stage of drafting provisions, you start modifying some specifics to fit the specific circumstances that the tribunal is to confront. In the case of, for example, crimes against humanity, there are certain key omissions which supposedly was tailored towards the specific circumstances of the Japanese action. When it comes to command superior responsibility, it was basically applied through judicial lawmaking, if I can put it like that. And we see repetitions of similar practices through the ages to today. I was wondering if some of my panelists would be able to comment on the significance of that practice and whether we should still continue to talk about retroactivity as a problem, or it's something that is just part and parcel of international criminal law as we practice it today. Second question I have is also something that was touched upon maybe vaguely, and that is the creation of jurisdiction through executive power, as opposed to the establishment of a tribunal such as the IMT through a treaty or the ICC. We have the example of the Tokyo Tribunal created through executive power. Something similar happened with the ICTY and ICTR, arguably. Whether that in any way affects the way we look at the soundness of their jurisdiction, legitimacy, acceptability, subsequent legacy of those jurisdictions. And last but not least, we have also questions concerning victor's justice. This is a very vexing question, I know, but whenever I come across discussions of victor's justice, I find myself scratching my head as to what that is meant to capture, the problematics of it. First, it seems to try to somehow undercut the standing of the accuser. So the victors sitting in judgment and in a position of accusing the wrongdoing of the vanquished. And then there is the related question of the legitimacy of the jurisdiction put under question because it is victor's justice. And I suppose by implication, there is no voice of the vanquished on the bench or in the proceedings that would somehow countenance this perceived deficiency. And last, and this is where I think someone from Japan, for example, I feel quite passionate about, and that is, does the notion of victor's justice, which supposedly undercuts the legitimacy of judicial proceedings, does it really have anything to do with Japan's own accountability? The simplest example, of course, I come up with is the fact that one car thief gets off the hook on the street doesn't make it right for me to steal. Likewise, it's no defense on my part that I was unlucky to get caught. Somehow this gets lost, this kind of what I consider to be very simple conception of one's own accountability, not relativized, but in a way absolute and unqualified, how that may affect the way we discuss the notion of victor's justice. I would invite comments from my panelists. Philip?
You raised quite a lot of very important points, and I'm not quite sure if I'll be able to be answered to relate to all of them, but I would just like to pick out one of the legal facets or the legal disputes which occurred in Tokyo and in Nuremberg, of course, which you mentioned, which is the criticism pertaining to retroactivity, the nulla poena, the principle. And as we all know, of course, this dominated the discussions relating to both tribunals, and it was addressed but ruled out in both Tokyo and in Nuremberg on accounts that all crimes were already existing under international law. And this was, of course, at least with the charges pertaining to crimes against peace, very questionable. And I think that the court itself also had some feeling of uneasiness with this retroactivity criticism, because I think you can find this reflected in the sentencing practice, and which I briefly touched upon in my presentation. It is you can trace in the judgment in Nuremberg and also in some separate opinions of the Tokyo judgment some reasoning that or some, let's say, some uneasiness with the question if the notion of crimes against peace was really established at that time, at the time of the war under international law. And this was the reason why defendants who were solely found guilty on charges regarding crimes against peace were not handed out the death penalty, only if it was combined with war crimes or crimes against humanity. So it was addressed, but in an indirect way in the sentencing practice, which was displayed in Tokyo and in Nuremberg.
First, I think victor's justice is a very political overloaded term. So, in this perspective, we must ask who is the initiator of this idea and who is the fighter against it. First, we must have in mind that the First World War was only 20 years or a little bit more over. And they made, let me see, not so really good experiences, let the loser doing the job by themselves. We were talking about the Leipzig trials. I think we can say that was a kind of farce that doesn't work. That they have had in their mind. That was the background, that they didn't wait until the end of the war to come together and discuss what we want to do with German and Japan atrocities. They were sitting, for example, in London, in other places, and they discussed in action before the crisis was coming to the end what they want to do. And on this hand, it's clear that the groups, they were sitting together and were really clear, pointed out that they want to bring the Germans and the Japanese war criminals before courts. It started officially with the St. James Agreement in January 1942, and then, of course, in Moscow, the Moscow Declaration. They make these two ways, bring them in before court where they did the atrocities, and that is exactly what they did. And that was clear that they want to do something together later on. That's the one part. And then now maybe I come to the point also to your question too. They discussed in this, let me see, groups, and of course the United Nations War Crimes Commission was the main one of them, International Criminal Court from 1944. They produced charters how such a court could look like included victims' participation in 1944. But then the Soviet Union and, of course, the United States argued, and others, that can fight back to us, what we maybe can do or will do later on. And that was, in my perspective, the point that they made the decision. We do it internationally in Europe, but only before, and in the so-called Far East with a lot of more. And they argued that is, of course, an ad hoc tribunal, but an international one. And in this, especially in the Tokyo, we have all the civilized world included in that. So, and for this perspective, it's not anymore a victim's justice, it is a justice of the free nations. So, I think that is an argument against that. And yeah, that's it.
Well, you know, in listening to this whole discussion about victor's justice, and I'd be very happy to admit I don't really know what that means, what the term means. But I wonder, isn't justice always meted out by those who are in a position to exercise control, who have power over the accused? That's even in domestic society. But I think the issue of victor's justice touches on the whole question of equality before the law. And we've raised it here today. The fire bombings in Tokyo and in Europe, nuclear bomb, the atomic bomb, were these themselves crimes that cried out equally as loudly as the common sense of mankind cried out for punishment of the perpetrators of the Nazi offenses? And the answer is, of course. Of course the common sense of mankind demands that people should be punished. And of course, if the Kellogg-Briand Pact was violated by the Nazis, well, should we look at the fact that if you go to the United States Department of State website and you look at who are the high contracting parties to the Kellogg-Briand under treaties in force today, you will see the US, the UK, and Iraq. Was the invasion of Iraq clearly, absolutely clearly a violation of the Kellogg-Briand Pact? But the question, I think, of victor's justice touches on this whole issue of equality before the law. And some of you know, because you've heard me say it, that at the US Supreme Court, they have those 4 words, equal justice under law. If it isn't equally applied, it's considered to be one form of victor's justice or another. And we have that problem today at the ICC, because we don't have enough countries that have subjected themselves to the rule of law to be perceived as part of a global justice system. It's a system in formation.
Thank you, Don. Now, I think, maybe just a few words from you, and then I open the floor to questions from questions and answers.
Sorry to give just one brief word at such a bad timing. Just related to the victor's justice discussion we are having had, I think one of the main reasons why this discussion is still going on in Japan, or especially with a view to the Tokyo trial, is that we have not only victors and vanquished, but there's a third group which should be mentioned in this context, the group of the victims. And if you have a closer look at who belongs to these relevant groups, we have certain overlaps and between the vanquished, the losers of the war, and the victims, and of course victims who are not present, who are absent in Tokyo, and also the question of if not partially some of the allied crimes amounted to crimes against the vanquished, the Tutkoku argument is of course also something which plays in this. And in Tokyo we have a lot of overlaps between these groups, and I think in Nuremberg the victim group was more or less incorporated into the victors group. So we didn't have this aspect of differing 3 different groups in Nuremberg. That might be one element which could have had influence on shaping the discussions related to victors' justice a little bit differently in Germany and in Japan.
Thank you. Now, I invite questions from the members of the audience. How does this work? Microphone. Let's start with the front row.
Just two quick comments. One about the importance of the crimes against peace. I think the whole point, at least from a legal philosophical perspective, the point about being murder was predicated on the idea of the division between just war and unjust war. To know a murder is a killing in a war is a murder if it's in an unjust war, which means you have to identify which part is the aggressive war, at least according to some of the natural law ideas, and that's why the crimes against peace was so important. But the point about the car thieves example, I mean, we are not talking of China, India, Philippines, of course, but in the other cases, it's one set of car thieves catching another set of car thieves, and then using that to legitimate more stealing of cars, like the French in Indochina or the Dutch in Indonesia. Whereas, what would have been maybe a bit more vanquished justice is, let's say, Indonesian judges, Indo-Chinese judges, Malayan judges, Hong Kongese judges, Singaporean judges, or Burmese judges in the Tokyo trial, which was simply did not happen. And we see there a power, so even forgetting the whole idea of Japanese victimhood anyways, the real victims of Japanese colonialism, apart from India very marginally and Philippines, China much more substantially, all the rest went unrepresented. And of course that's victor's justice.
Thank you. Then over here.
I have a question for Professor Austin. Could you comment on the reluctance of the Japanese legal community today to take an interest in or to take ownership of the Tokyo trial? I find this phenomenon it makes sense and it doesn't. It doesn't in the sense that it was the earlier generation of the Japanese legal scholars who celebrated the significance of the Tokyo trial as for its contribution to furthering the cause of justice and accountability. So why shouldn't the Japanese legal scholars today would not do the same? And yet it seems to make sense in the sense that they are Japanese and therefore they do not want to accept its legacy, positive legacy. If so, that would mean just sheer out of patriotism, maybe they are reluctant. But if so, it's really odd. So then I would have to think further, and perhaps I might say possibly they have a deeper insight in into some aspects of the Tokyo trial which non-Japanese legal scholars can't see, and therefore they have some reluctance. Perhaps that's the only valid explanation I would have. So perhaps you could enlighten me on this particular
Is there
topic.
any other question that's burning in your mind before I give the floor to Philip? There is one burning question from the back.
Thanks for your wonderful presentation. My name is Mao Xiao. I'm a part-time researcher at the Center for Tokyo Trial Studies in Shanghai. And my question is about the murder charges. I believe both Professor Austin and Professor Form mentioned this charge. Some people say that this is a legal innovation at Tokyo trial. My question is, do you think that it is right for the prosecutor to charge the murder counts? Let me briefly explain this question. This issue is also closely related to the principle of non-retroactivity. People argue that prosecuting aggression is a violation of the principle of non-retroactivity, and I believe that some prosecutors at Tokyo trial also think that this is a problem, and that's one of the reasons why they raise the murder counts. I remember the British prosecutor, Commons Carl, argued that killing civilians as well as killing soldiers in an unlawful war constitute murder, and as murder is considered as a crime in all civilized nations, so if they prosecute the aggression based on the murder counts, it would not be a violation of the principle of non-retroactivity. So according to your opinion, would this be a correct idea to prosecute aggression based on murder counts? Thank you.
Thank you very much.
Yes, thank you for these very insightful questions. I would first like to address Yuma's question, and to be honest, I would actually like to pass it on to my Japanese colleagues in Japan, but I'll try to answer it as far as I can. Yes, it is quite puzzling and surprising to see that even though some of the most compelling visionary assessments of the Tokyo trial on very sound legal reasoning were presented 70 years ago by some, at that time, already leading Japanese legal scholars, most of these works are completely forgotten today. Even among legal academics who specialize in international criminal law. This is a quite interesting thing. And I don't know if we can speak of causal relations, if there's a causal effect of the discussions pertaining to victor's justice, which decisively shaped the Japanese way of viewing on the Tokyo trial, and if this led to the impression or to the perception of this trial as a politically mined field of law, which is not suitable to full-fledged legal scholarship, it's not worth to conduct research on such a politically mined field of, or too risky maybe to conduct research on this field of law. This could be maybe one reason, in my view. Another reason is maybe they wouldn't find a huge, I think even if legal scholars would expound upon such matters more in detail, they wouldn't find an audience which is really interested in that. This is maybe a decisive difference as compared to the debate we now have in Japan among maybe historians. You mentioned that yesterday, and political scientists, which are very active in this field and are already and are also publishing a lot of very important works in recent years. Maybe, with all respect, I would like to just describe my view of the recent discussion in Japan. You, I think, are definitely one of the pioneers, and at the same time, your book was published. Madoka Futamura's book was also published, and of course, Cryer and Boyce's book, and some other books were published. But at first, they were all published in English. And even those published by Japanese scholars like you were at first published in English. And afterwards, I know, of course, you hurried up to present a Japanese translation, which was also very well received in Japan. But at first, this discussion 10 years ago had only very limited repercussions in Japan, especially among the legal academics. And it could, if one could even question if this was actually, even though it was conducted mainly by young Japanese scholars like you, if this was really a Japanese discussion. I don't think it was a Japanese discussion. Well, as to the legal scholarship, yes, I for myself are gratefully in a grateful position to bring some students in Japan to the attention of the historical origins of what is now present international criminal law. But I see in the reactions of my students also that a lot of your lawyers still question the legal validity of the trial, and this might still play a role, yes, in Japan. And for the next question, just one very brief word regarding the murder charge. In my understanding, this was nonsense, complete nonsense. Yes, it had to do with the modification of crimes against humanity. They were modified in order to make them applicable to combatants, enemy combatants as well. But as was already pointed out previously, the basic idea was, or the background was Pearl Harbor, and other acts which took place in an illegal war of aggression were not qualified to be acts of combat, and therefore the wars and customs of law, the notion of war crimes or crimes against humanity in this case, would not be applicable, and killing somebody in such a war would amount to an ordinary murder. And this was, I think, rightly ruled out by the court, by the majority judgment in Tokyo.
maybe I try it again in a picture. The judges, they have had in their mind, the only thing it's applicable for them is the charter. They looked at the charges and they didn't find murder as an independent crime. And that was the argument in the judgment, that they threw that out and said, we cannot find the murder as an independent crime in our charter. Depends then, it doesn't matter for us what you are described, we put it out. They did not more. That was a formal thing, not an intellectual or juridical background. It was a formal thing. We have nothing to do with that. Depends on, it's not our jurisdiction. It's not written down. That murder is in crimes against humanity. That's a different thing. That's not an independent crime. Except also crimes against humanity by themselves was not an independent crime in the charter. So that was the background. They throw that out. Sometimes it's very easy.
Yes, you may.
What I remember is that in the judgment, the reason they rule out this charge is not because it's not within jurisdiction of the court. They did not say this. It's because it is repetitive. It is repetitive to crime of aggression, and it is repetitive to war crimes. I remember in the judgment says the killing of civilians is covered by war crimes, while the killing of maybe soldiers is covered by crime of aggression. That's why the court think it is unnecessary to rule on the murder counts. But it does not say that it's not within jurisdiction of the court. And also, my question is that many people would argue that crime of aggression or crime against peace would be a violation of the principle of non-retroactivity, because maybe the majority opinion of the court think that it is not a violation of the principle, so they keep on using the crime against peace. But what if it is wrong to argue that using crime against peace is not a violation of the principle of non-retroactivity? I mean, it is possible to argue that if the prosecutor used the murder counts, it is not a violation of the principle of non-retroactivity. Do you understand what I mean?
Maybe just one very brief comment. The question of the applicability of international humanitarian law, or at that time, as it was called, the Wars and Customs of Law, especially the question whether a soldier would be granted the status of a combatant or not. This question is not depending on the legal qualification or the nature of the war in which it occurred. So even if it was an illegal or aggressive war, this legal protection was still applied to all the combatants, and that's why killings in such wars were not qualified as ordinary murders, but rightly as killings within the legal framework of war crimes or other international crimes.
There are questions from the middle.
Hi, thank you. Could I just follow up on the question or on the comment by Professor Totani and Professor Austin, why succeeding generations somewhat disowned the positive attitude of their predecessors? This could be also tied with succeeding political developments, namely that how would you say, those who positively evaluated the Tokyo trial on the Japanese side then soon became tied up. Even they tended also to be quite American friendly. For example, Yokota Kisaburo then became an advocate of the Anzen Hosho Joyaku, the US-Japan Security Treaty, and that was very unpopular among left-wing and right-wing people, intellectuals alike in Japan. And Yokota Kisaburo, for example, was very much vilified as a chameleon who changed positions, and he lost all his authority then in later years. And this happened also with other people who advocated the Tokyo trial. So this ambivalence towards the US in later decades might have played into disowning the Tokyo trial as well. And one question regarding the retroactivity, this is always puzzling me a little bit because it is so much emphasized, but even Jackson also argued that this is not necessarily a principle which is valid in international law at the time. It is an analogy from the municipal law, and even the Japanese observers, like for example Yokota Kisaburo or Michitaka Kaino, didn't insist on this retroactivity principle, and said, well, this is a revolution of international law, and so every revolution brings new things. So it is natural that retroactivity here is not valid. So I'm not sure why everybody's so hung up on this retroactivity thing.
Thank you. Would you like to respond?
Again, to present some comments, but as you addressed me directly, I would briefly like to answer. Yes, I think it is possible to constate a kind of disillusionment among the first generation of scholars and academics who actually made a positive assessment of the Tokyo trial during or shortly after the trial. In the 1950s, the trial gradually faded away as a subject of legal debate in Japan, and of course the Cold War and the atrocities committed by the United States and Vietnam and other areas, they of course formed the background to this kind of disillusionment. But the one scholar you mentioned, Yokota Kisaburo, he actually upheld his views, and even at the end of the 1950s, in a Festschrift, which was publicized in Germany for, at that time, quite famous German international law scholar, he again took up the issue of crimes against peace and the notion of the illegality of wars of aggression. And he stated again that now, meaning the 1950s, nowadays it is without doubt an established principle under international law that a war of aggression is illegal and criminal under international law. So he kept up with his views, and some other scholars, like the criminal law scholar Dando, they actually never again turned back to the Tokyo trial. They went on and led the discussion with regards to domestic criminal law, and they never again took up the Tokyo trial. Maybe the Tokyo trial just played one positive role in the shaping of the post-war Japanese criminal procedure law. The Tokyo trial served as a model for the adversarial system, and it was Dando who was deeply impressed by the roles of the American defense lawyers in Tokyo, and this influenced the way he drafted what was to become the code of criminal procedure in post-war Japan. And but to the basic question, why are these people not appreciated anymore? They are appreciated, but not by their works on the Tokyo trial. And as I said, among my colleagues in Japan, among legal academics, hardly, with very few exceptions, hardly anybody takes up this subject. Yes.
Thank you. Perhaps now that we have wrapped up this round of questions, I would like us to go back to taking several questions and then give the panelists the opportunity to respond. Professor Krepp had, then Diane.
Thank you. I wanted to press you, Dr. Hayashi, to answer the question raised by Dr. Banerjee concerning the car thief analogy. At the very time that the war crimes trials were taking place, Dutch forces in Indonesia were committing war crimes against Indonesian civilians. French forces in Indochina were committing war crimes against Vietnamese civilians. Not long after, British forces were committing war crimes against civilians in Kenya. So it's a very valid point to say that one car thief cannot complain if he is indicted when others are not indicted. But if the indictment is done by other car thieves, apparently with the intention of excluding an interloper, then the moral issues become rather different.
Thank you.
I'm going to ask a question of substantive criminal law, if I may, which is my understanding from your presentations, and I confess I have not looked at the statute of the IMTFE in a long time, is that for the most part, the Crimes Against Humanity article looks a lot like the Nuremberg Charter, except that they deleted the words against a civilian population. Did I get that right?
And religion was omitted.
And religion. So my question is, and Professor Austin said, to what extent did the Tokyo precedent affect crimes against humanity going forward? Not at all. What if it had? I mean, what does it mean to delete the concept of against civilian population? Normatively, is that something that should have been considered in previous formulations, or did it effectively so collapse the crime into the concept of war crimes that it rendered it largely a nullity?
Maybe one more question. I think there was one from Mr. Pace.
Thank you, Bill Pace with CICC. It's kind of a comment on both the last panel and this panel, and the relationship between this issue of victor's justice, which has always, in the last 50 years, been applied whenever someone referred to Nuremberg or Tokyo, etc. And one of the real, I think, things that I appreciate from this conference today is how that is a very superficial label, and it really needs to be dissected and expanded. It's more multidimensional, etc. I'm looking forward. The Rome Statute was clearly, this was a key issue in the drafting. If the P5 wanted a court controlled by the Security Council, which many would have superficially described as a victor's court, the like-minded group did not, etc. The way in which the court is, the ICC is achieved now in terms of its independence is even more remarkable on the basis of the discussions about the Nuremberg and Tokyo charters, etc. And yet the ICC still suffers somewhat from the victor's thing because of selectivity, issues that Don raised, etc. So my hope is that this area, this issue of really unpacking and dealing with the multidimensionality of the victor's court simplicity is something the Academy and academia will take further. Thank you. I mean, just the whole idea of an in situ court, which is often called for, how would that be different from a show trial to some degree? Because it has a lot of the same elements. So I really think the more we could deal with these more holistically, it would be quite valuable.
Thank you. Would Philip like to respond to Diane's question?
Thank you very much for this stimulating question. The omission, the deletion of the wording against any civilian population, at least in a retrospective, that did not make much sense, because the very reason why this new concept of crimes was introduced was to make punishable or prosecutable crimes which until then did not fall under the scope of conventional war crimes, especially acts committed by the offending state against its own nationals, like in Germany against the German Jews, or inhumane acts committed against nationals of third states. So if you take away this limitation, we will encounter difficulties in distinguishing between conventional war crimes and crimes against peace. And if you have a look at the further development of this notion in international criminal law, I think it makes sense that this idea, which popped up in Tokyo, was never again recurred to. The target of crimes against humanity being members of the civilian population, being civilians, is a crucial element, and it was construed as such an element in all other wordings of the crimes against humanity, which we had in the Control Council Law number 10, and of course in the ad hoc tribunal statutes. And another thing which should perhaps be mentioned in this context is also the uneasiness which the Allied powers had with the concept of interference in internal affairs of states, which was the reason why a nexus between crimes against humanity and the other two crimes was made a prerequisite for the application of crimes against humanity. And these two, and this latter element was eventually omitted. And if you have a look at the wording, the ICC Statute, this link with the other crimes has been deleted completely. And this is, I think, a development which can be assessed positively in international criminal law, together with the fact that the Tokyo wording was not taken up again. I think this has been, at least in the retrospective, a sound development which also matches the initial aim of this notion.
Thank you. I spent 20 seconds responding to Professor Krebs and Mr. Pace's question, and then I give the floor to each panelist for one concluding observation each. I think this victor's justice label has lots of components, and we need to unpack them. I totally agree. My question was, yes, it's one matter to allege the lack of standing on the part of the accuser, that accuser being the victor. Another question is the legitimacy of the jurisdiction created to adjudicate your crimes. Does the lack of standing of the accuser taint the legitimacy of that jurisdiction, such as the IMTFE? The third question, which I think is not affected by these two questions, is what to do with one's own accountability. It doesn't matter who the accuser is. Your accountability should arise from your own action, not who the accuser is. That's how I was approaching the question of victor's justice. Now, I would start with Philip, and then Wolfgang, and then Dawn has the final word. Do you have any final concluding remarks about the session?
No.
No. Okay.
Maybe somebody else would.
I try to do a summary for me, what I've heard until now, not only on this panel. For me, it's pretty clear that the political and military situation in Europe and in the Far East was very different. And at least for me, I see three different scenarios. The first one was from 1931 up to the end of the World War II in China. The second one was from September 1939 in Europe and in North Africa. And the third one, it starts in the end of 1941 in the Pacific Asian region. And in this perspective, it looks like that this created three different, juridical areas where they have specific crimes that appears. Maybe that's the summary for me until now. Maybe tomorrow I have another thing in my mind.
Then Philip, very quickly, and then Dawn, you have a final.
A very simple question, which is not directly related to our a little bit technical legal discussions we had so far in this panel. Could this conference or this panel have taken place in Tokyo? I think not. And it is interesting to note that, as was already mentioned yesterday, no comparable academic conference is taking place in Japan, so far as I know, this year to commemorate the 70th anniversary of the judgment. And also, physically, the court room still exists or was recreated, and it is now again where it was before the trial was initiated. It is in the premises of the Japanese Self-Defense Forces, the Ministry of Defense. And speaking of that, the Academy of Defense, University of the Self-Defense Forces in Japan, has a huge conference room, and in one corner it has a special exhibition of the separate opinion of Pall. And I think this doesn't, I don't have to comment on this anymore. Yeah.
Thank you. Don?
With respect to this whole question that we've been talking about, victor's justice, this big, broad question, something that seems very clear to me is that if the powers that sat in judgment at Nuremberg and Tokyo meant what they said about the rule of law and felt regret about the horror of their own uses of force in the war, that it was really and is incumbent upon them to make good on the promise of never again by establishing a framework which will abolish war. And it's an ironic truth that after he retired from the military, one of the great proponents of peace on this planet was Douglas MacArthur. And I brought along a book because you have to see it with your own eyes to believe that he gave speeches in the 1950s saying to the world that the world needs to be led by the United States in an effort to abolish war for all countries to renounce, as Japan had renounced in its constitution, the right of belligerency. He went further. In 1957, he gave a talk in New York City where he said, and this is a quote, that the American government wants to, quote, keep the American people in a perpetual state of fear so that they will continue to approve the exorbitant military spending budgets that would destroy the United States. I use that only as an example, but one of the things I'd like to just touch on before closing is the legacy of Nuremberg and Tokyo today vis-a-vis the crime of aggression. Germany has ratified the Kampala Amendments on aggression and has subjected itself, therefore, to the jurisdiction of the International Criminal Court. Japan, one of the leading countries in the world in terms of its membership in the ICC, has not done so. I don't have time to even begin to ask the question of why not, but I would hope that they would. We all know that if we want to advance human rights, we have to deter human wrongs. That's one way of doing it.
Thank you, Don, for that profound concluding remark. And I would like to thank the audience for the patience. We are overshot by something like 6 minutes. I hope it's going to be fine for the next item on the program. Thank you for your attention.